Earnest money essentially is money that's set aside by the buyer, it's held by the buyer's attorney, and the purpose of that money is to act as liquidated damages in the event the buyer is unable to execute the contract. What happens to the earnest money if there is a breach of the contract? Well, that sort of depends. If the buyer and seller mutually agree that the breach is legitimate, then the buyer would receive the money back. If there is a dispute between the buyer and the seller concerning the earnest money, that money is frozen until that dispute is resolved. And that dispute can be resolved by one or two ways. The first way is there has to be mutual consent. They both agree upon it. The buyer gets their money back. The second way the dispute is resolved is that it has to go to court and the money is then released to whatever party the judge instructs. The earnest money can be returned to the buyer upon mutual consent of both parties. That if there is a dispute, that dispute has to be resolved before the earnest money can be returned. Do you have any stories about earnest money and what happened to it during a real estate transaction? Well, leave them in the comment section below. I'd love to hear about them.